Marche Brooks. Ms. Brooks is charged with domestic violence battery. I find probable cause. I'm going to set bond in the amount of $500. Appoint the Office of the Public Defender. No contact with Marquez Griggs, who is a step sibling of Ms. Brooks. Normal? BRC?
BRC, yeah.
Yep, all right.
Thank you.
Does Ms. Brooks reside at 2416 Dardanelle with Marquez Griggs?
Sir?
Do y'all reside together at on the Dardanelle?
Yes, sir.
All right. All right, well, I'm going to require that you not return to the address where this occurred, 2416 Dardanelle Drive. You return one time with law enforcement to pick up personal effects.
Your Honor, it looks like Ms. Brooks also has a few pending domestic violence batteries with her mother in the juvenile court system.
Okay.
So I don't know if she has somewhere else to go, because that's a different address. So I don't know if now she's at the Dardanelle address because she can't live with her mother. So I don't know if there's a place for her to live.
Okay. Well, I'm ordering that she not have contact with her step-sibling and that she not go back to where this occurred. If she can't go back to the place that she usually resides because of other issues, she's just going to have to find a place to stay.
Judge, it's
Mr.
a
Parker?
non-issue.
I'm sorry?
It's a non-issue. She doesn't have to go back to the address.
Okay, all right. All right, thanks, folks.
And you said she could go back one time?
One time with law enforcement. All right. Horace Washington. Mr. Washington is charged with trespass on property after warning. I'm going to find probable cause. Is Mr. Washington interested in resolving this case this morning?
Yeah.
State, do you know what Mr. Washington's priors are? This is a trespass, apparently at the Colonial Caribbean Sunshine Bakery.
Yes, Your Honor. Mr. Washington has 7 prior trespass charges, as well as a total of 17 misdemeanor convictions and 5 felony convictions.
Okay. Do you have a recommendation if Mr. Washington wanted to get this resolved today?
Yes, Your Honor. State's offer was going to be an adjudication 20 days in the Orange County Jail with credit.
How many days does he have in? 2? 2 days. Okay. All right, Mr. Washington, if you wanted to resolve this case today, I would sentence you to 17 days, give you credit for 2 for a total of 15 more days.
Wait, hold on. She said I have what? Seven trespasses. What kind of 7 trespasses I have? What 7 trespasses I have?
Okay.
Judge, I think that we should go
Wanna
ahead
pass this
and
case?
ask for ROR today.
All right.
And
All right, he's been in jail on 2 days on a trespass. I'm going to go ahead and find probable cause. I'm going to release him on his own recognizance. I'm going to require that he not return to 2528 West Colonial Drive, Caribbean Sunshine Bakery. I'm going to appoint the Public Defender's Office to represent him. Good luck, Mr. Washington.
thank you.
LaDonna Williams. Ms. Williams is here on an out-of-county warrant on a violation of probation. I'm going to stay the bond at $10,000 on that warrant. I appear to have 2 copies of the same thing.
Yeah, and most of them is out of county, agency.
Okay, all right.
Yeah.
All right, good luck. Joseph Bajardi. Okay, Mr. Bajardi appears to have warrants out on 2015 CF 14272. This appears to be a violation of probation. There's a warrant signed by Judge Aft with no bond, not modifiable. Stay the bond at none. Appoint the Public Defender's Office to represent Mr. Bajardi on that case. On 2017 CF 12977, appears as though Mr. Bajardi charged with use of an anti-shoplifting device and petty theft, a first-degree misdemeanor. Apparently, there's a capias. I'm gonna stay the bonds at, 1,000 on the anti-shoplifting device and, 250 on the petty theft for a total of 1,250. Appoint the public defender to represent him on that. And then on 2017 CF 12114, I'm finding probable cause on all of these. There's a capias on the charge of use of anti-shoplifting, control device and petty theft. I'm staying the bonds at 2,000 on the anti-shoplifting and $1,000 on the petty theft for a total of 3,000. Appointing the public defender to represent him on that. And on 2017 CF 538A-0, it's a failure to appear on the charge of grand theft third degree on the outstanding warrant. I'm gonna stay the bond at none and appoint the public defender's office to represent Mr. Bujardi. Okay, those are all my move-ups. What's next?
The big red.
The big pile?
Yeah.
Okay. All right, is this Travell Coppage?
Yes, sir.
All right, Mr. Coppage is charged with aggravated battery on a pregnant person, battery by strangulation, and tampering with a witness. This is on a warrant. I'm gonna find probable cause. I'm gonna set bond on the aggravated battery on a pregnant person in the amount of $5,000. Battery by strangulation, $1,000, and tampering with a witness on $1,000. No contact with the victim in this case. No return to the location. Appoint the office of the public defender to represent Mr. Coppage.
Judge, did you set bond on the tampering charge?
I did. I think it's 5, 1 and 1.
Yeah, 5,100, 1,000, 1,000.
After speaking with Mr. Coppage, I believe, based on his ability to post bond, will be in the neighborhood of $3,000. So we were gonna ask if the court could set bond at $2,500 on count 1, and then 500 and 500. It's still a reasonable bond under the circumstances.
Okay. I'm satisfied with the bond that I previously set. Mr. Coppage can bring up bond issues with the judge assigned to his cases.
Thank you, Judge.
Thank you, Mr. Parker. Matthew Gibson.
Yes, sir.
Mr. Gibson's charged with aggravated assault with a firearm. Based upon the charging arrest affidavit, I'm finding probable cause.
Judge, I believe that there is probable cause. However, I think he has a good stand your ground argument,
All right.
and I think that the court should take that into consideration when setting bond in this case, as I believe he was in his residence.
State?
Your Honor, at this time, the burden is just probable cause, so I think, Your Honor, sorry,
No, go ahead.
can you hear me?
I'm struggling to
Okay.
hear you.
I think at this point, the standard is just probable cause, so the stand your ground motion is an issue for much later. I think Your Honor should just set bond based on probable cause finding.
All right. Do you have a position on bond?
Not as to an amount, Your Honor. It looks like Mr. Gibson has just 2 prior misdemeanor convictions and 1 prior felony. I would just be asking for no contact with the victim at this time.
All right. All right. Based upon I'm finding probable cause, based upon the facts and the nature of the charge, I'm gonna set bond in the amount of $5,000. I'm gonna require that Mr. Gibson have no contact, direct or indirect, with the Dealani Mangual. He's also not to return to the location of 3700 Curry Ford Road, number G6. If that's where he resides, he's permitted to return one time with law enforcement to pick up personal effects. I'm going to appoint the public defense. Well, what do we have here? 1,400 a week.
And it just said
So he does not qualify at 1,400 a week?
1,400.
1,400, yeah.
Well, weekly, gotta make $463 a week.
I'm sorry?
463 a week. Well, one of him, he made 1,400.
Right, so he does not qualify. All right, I'm not gonna, Mr. Gibson does not appear to qualify for appointment of the public defender.
Judge, would waive the reading of the charges in Mr. Hood's case?
Mr. Hood's case? All right. I'm moving fast, Mr. Parker's work moving faster.
Doing
All
good.
right. All right, Mr. Hood. All right, apparently Mr. Hood has a pending misdemeanor for which he received a notice to appear. For domestic, is that right? Notice to appear on a DV battery?
Yes, it was a summons issued.
I'm sorry?
It was a summons issued and served
Okay,
with the same victim.
okay. All right, State, do you, other than no contact, do you have any position on conditions of release on
Your
Mr.
Honor,
Hood?
considering the charges in this case and the dangerous nature of them, state would be requesting the bond be stayed at none.
Mr. Parker?
I don't think that there's a legal basis to ask for no bond in this case. We'd ask the court set bond at $2,500 on each count, and he's legally entitled to a bond. These are F2s.
Okay. All right, I am going to, I'm gonna set bond, in the amount of, $3,000 on count one and $3,000 on count two, for a total of $6,000. I'm gonna require Mr. Hood to have absolutely no contact, directly or indirectly, with, where'd it go? Tarita Hood, and not to return to the residence at 752 Sherwood Terrace Drive, number 303. Mr. Hood has a pending DV case, and he has these charges against where Ms. Hood is the same alleged victim. I'm going to order that Mr. Hood be permitted to return to the marital home or his home one time in the presence of law enforcement, pick up personal effects, not to have any contact whatsoever, directly or indirectly, with the victim in this case. He's also not to consume alcohol or recreational drugs. He's not to possess firearms or any other weapons. So I'm going to appoint the Public Defender's Office to represent Mr. Hood on these charges.
There's no about the case that he's out on bond, the MM case.
He's not out on bond. Apparently, there's a summons.
So you would take no action?
I'll take no action on this, on the case for which he's expected to be in court on August 6th.
Okay.
Alberto Rivera Rodriguez.
Judge, as to probable cause for the carry and concealed firearm offenses, given that the firearm was not concealed under the seat, next to the seat in the glove box, it was on the floorboard in open view. The case law is very close on whether this can be carrying a concealed firearm if it's actually not covered by anything. So I just asked the court to consider that when setting bond on those counts, and he does qualify for pretrial release.
All right. State on the carrying concealed firearm, 2 counts. Do you want to respond to the, Mr. Parker's argument, there's no PC?
Well, Your Honor, according to the arrest affidavit, one of them was found stuffed between the driver's seat and center console. That is not in plain view. Looks like, sorry, I'm trying to read this quickly. As to the count involving the handgun lying on the driver's front floorboard, state's argument for PC would just be that it's in plain view once the car door was open, but other than that, it is not in plain view. If Your Honor isn't going to find PC at this time, state would just request 24 hours to provide additional information for probable cause as to that count.
Is the case law, Mr. Parker, it seemed to me there was case law once upon a time, it may have been overruled, that as long as you can't see both sides of the firearm, it's concealed as to one side of the firearm. That case never seemed to make a lot of sense to me, but if it's laying on one side, you can only see one side, therefore it's part of it's concealed.
I'm not familiar with that case. I am familiar with cases where the gun is on the floorboard, but it's covered by something, like say a folder or something, then that would be carrying a concealed firearm, because despite it being on the floorboard, it is concealed by something. The issues are when the police come to your door, if there's a handgun laying on the seat, that handgun is not really concealed because it's readily apparent to the officer who shows up at your door side.
And Your Honor, state's response to that would just be that if the firearm is on the seat, then yes, obviously an officer can see this in plain view upon approach of the vehicle. Upon approach of a vehicle, the officer cannot see what is on the driver's side floorboard.
All right. Mr. Parker, would you prefer, I'm going to find probable cause as to the firearm, which is described as being stuffed between the driver's seat and the center console. I'm not going to find probable cause as to the firearm as described in plain view on the driver's front floorboard. I can, would you prefer on Mr. Rivera-Rodriguez's behalf that I don't find probable cause and give the state additional time to supplement the arrest affidavit, or would you prefer that I set conditions release at ROR on that and waive my finding of no probable cause? Does that make sense?
Yes.
So if I don't find probable cause, I'm going to give the state time, and Mr. Rivera-Rodriguez is going to stay as our guest until, usually give the state 48 hours?
24, and
24.
then one more 24 if we need it.
I would give the state 24 hours, so that would hold Mr. Rivera-Rodriguez another day. If you want to waive that objection to probable cause, I'll set him an ROR for the second handgun, because I think and I'll set bond on the first handgun.
He prefers the latter and just set condition of release today.
Okay, all right. All right, I'm going to set bond on the carrying concealed firearm at $2,500. The other, I'm setting ROR. I'm appointing
The first one is 2,500, the second one is.
$2,500, second one's ROR.
You find PC for the second one?
I'm going to find PC for the
Okay.
second one. I think it's arguable. I could choose not to find PC, and Mr. Rivera-Rodriguez could stay our guest for another day. Does that make sense?
Yes.
You got me? All right. And then we talked all the way around that, we came back to where we started. All right. Then as to the charge of domestic violence battery, on that case, I'm going to, does Mr. Rivera-Rodriguez have any prior domestic violence charges?
Sorry, Your Honor, I'm checking. Not in Florida, Your Honor, and it looks like not out of state either.
Okay. And do we have Ms. Ferrer here this morning? It looks like we don't have anybody. All right, I'm gonna find probable cause on the charge of domestic violence battery. I'm gonna set bond in that case in the amount of $1,000. I'm going to require that Mr. Rivera Rodriguez have no contact directly or indirectly with Karina Ferrer. It appears as though the officer arrived at the Circle K on OBT. Does Mr. Rivera Rodriguez reside with Ms. Ferrer?
I believe so, Judge.
I'm sorry?
I believe so, yes.
All right. I'm gonna order that Mr. Rivera Rodriguez not return to the location of 740 Bennett Drive. Nope, that's a club. It looks as though Mr. Rivera Rodriguez resides at 1907 Reef Club Drive in Kissimmee. So we believe that's also where Ms. Ferrer lives. All right, so he's permitted to return to the location they share one time to collect personal effects.
He's listening, you can go back one time with the sheriff's office.
Can I hear him, sir?
Oh, he was.
You were
just telling-
explaining to him what I was just gonna say?
And where he was going to live, yes.
Okay. All right, so you're not to have any contact directly or indirectly with Ms. Ferrer. You're not to possess any firearms or weapons, consume any alcohol or recreational drugs. You can return to location where you reside if it's with Ms. Ferrer one time with law enforcement to collect personal effects, no furniture or other large items, just your personal effects. And I'm going to appoint the public defender's office to represent you on the domestic violence battery charge. I think I've already done so on the carry and conceal firearm. Mr. Reese, what do you have this morning, sir? Pleasure to see you on this fine morning.
Well, I'm glad to see you. I mean, as long as you have to work, I might as well have to work.
Fair enough.
I represent a guy, first name Mohammed, last name El Ayade. There's no space between the L and Ayade. It's E-L-Y-A-D-I.
Okay.
He's here on the charge, but he's out of bond on misdemeanor paraphernalia. Just didn't want that bond revoked.
Okay. Where are we with Mr. Reese's client? Can we jump to that one, or we wanna?
Can you guys give,
Pardon me?
I was asking correction, can you get his client
Is he convenient? All right. Do we wanna call this gentleman, since we've got him in the courtrooms, to move him along while we wait for Mr. Reese's client?
I'm sorry, Mr. Reese, who's his client?
Mr. Reese, would you approach the clerk so you can give her the spelling of your client's name, because it's hyphenated and there's L's and other letters in it?
I'm asking what time these normally start, 'cause it says on mine at 11.
Right.
No, I'm really happy, because I was
All
about
right.
to text, I said, I'm not gonna bug you, I'm not
All
gonna do
right,
that.
give me the top one, I think that's this gentleman.
Yeah.
I think so. Is this Nigeria Jones?
Yes, sir.
All right. Mr. Jones is charged with domestic violence battery. Is Miss Jenkins here? All right, I'm gonna find probable cause in the charge of domestic violence battery. I'm gonna set bond in the amount of $500.
Judge, we would ask that he be interviewed for pretrial release if possible. For some reason, my paperwork indicates that he was not interviewed.
He was interviewed, he does not qualify.
He does not qualify? All right. So I guess that's gonna be no. I'll set bond in the amount of $500. Require that Mr. Jones have no contact directly or indirectly with Elise Jenkins. Does Ms. Jenkins and Mr. Jones reside together?
No, sir.
Okay. All right, so you're not to have any contact, Mr. Jones, with Ms. Jenkins directly or indirectly. You're not to possess firearms or weapons while you're on release. You're also not to consume alcohol or recreational drugs. I'm gonna appoint the public defender's office to represent you on these charges. So it's PC 500. No conflict. Okay, and I got this pile back?
Yes.
Oh, and this is Mr. Reese's client.
Yes.
All right, so while we're waiting for Mr. Reese's client, I'll just keep going.
Oh.
Is that what we're doing?
That's not a stop. Oh.
Let's finish domestic and then we'll bring some.
Okay, all right.
Okay.
Whichever, whatever order you wanna do them, it's fine with me, cause I gotta be here either way. All right, is this, Malika McDonald?
Yes, sir.
All right, Ms. McDonald's charged with domestic violence battery.
Judge, we have no PC argument, but as far as release, her risk assessment was very low, and she does qualify for straight PTR. She
All
would
right.
prefer that.
All right, so did you wanna make the, PC argument, or do you wanna waive that argument? For me to release her on pretrial release?
Waive the PC argument.
All right, all right. I'll find probable cause so that I can release Ms. McDonald on pretrial release. I'm gonna require that she have no contact with Josue Adolphe. I understand they have a child together. Ms. McDonald, do you and Mr. Adolphe reside together?
No, sir.
Okay, all right. All right, you're to have no contact directly or indirectly with Mr. Adolphe. You're not to consume alcohol or recreational drugs or possess weapons or firearms. I'm going to appoint the Office of the Public Defender to represent you. Good luck. Well, you were right on it. I look over there and I already have the phone. These guys are on it. Mr. Reese, when you see your client, just wave your arms or let me know, all right?
Okay.
All right, Jerry Pravilas,
Yes, sir.
is charged with domestic violence battery.
Judge, we waived the PC argument, but asked that the court consider placing on PTR as he does qualify for straight PTR.
Okay, does he qualify for pretrial release?
He does qualify for free trial.
I'm sorry, I heard he qualifies?
does.
Okay. All right, I'm going to find probable cause, release Mr. Pravilas on pretrial release. Require he have no contact directly or indirectly with Ashley LaPlante. Do they reside together?
Yes, ma'am. Yes, sir, but
All right.
she's living with her mom right now. She moved
Okay.
in for her mom right now.
All right, well, do you know whether she has vacated?
Yes, she's with her mom right now. She's been there since last night. She's already vacated already.
Okay. All right, what I'm gonna do is I'm not gonna make a finding or order as a condition of your release that you not return to the location, because we might have a maintain separate residences? Look at you, all right. I'm gonna order that you maintain separate residences. If it turns out that you both wanna have that residence and you've got personal effects at that residence, I'm permitting you to go back one time with law enforcement to collect your personal effects.
Yeah, just my
Um,
work clothes.
If you're not gonna be in the same place and she's out, you can go there, but you're ordered to maintain separate residences. You're also not to consume any alcohol or recreational drugs while on release. You're not to possess firearms or weapons. I'm gonna find you qualify for the appointment of the public defender. I'm gonna appoint the public defender's office to represent you on this charge. Thank you, Sharon. You totally got my back on this.
Thank you.
I'm struggling and you. All right. Jasmine Rainey. Apparently Ms. Rainey does she have a notice to appear for August 15th on a felony? Is that what I'm looking at? She's got the open grand theft and possession of less than 20 grams, and she's got a court date. Is she not out on bond?
It's an open case.
Okay, what does that mean for me? It's an open case, which means,
The case has been continued, and the bond is probably still active.
I'm sorry,
The case has been continued,
And the bond?
is probably still active. It's shown open in the, state
okay,
attorney.
all right.
And Judge, those two, the cases that she's out on bond on occurred on the same day. They're not separate incidents. They have separate case numbers, because when you get arrested for a crime, and then there's an intro to contraband, they make it a separate case number. We'd ask the court
Gotcha.
not to disturb those bonds and set bond in this case at $1,000.
All right, well, let's do this in reverse order, on the new, or the correct order. Ms. Rainey is here on charge of battery, dating violence. All right, I'm gonna find a factual basis on the battery, dating violence. I'm gonna set bond in the amount of $500. Require that Ms. Rainey have no contact directly or indirectly with Daquan Phillips. Do they reside together?
No, sir.
Okay. No contact, no contact, no, alcohol or recreational drugs, no weapons or firearms. So she's out on bond on the introduction of contraband.
And Your Honor, state would be requesting that that bond be revoked for committing a new law offense while out on bond.
All right. I'm gonna go ahead and revoke the bond on 2018 CF 1372A-0 and 2018 CF 1380A-0. And Ms. Rainey can request that that be addressed by, I think, Judge Thorpe. Nope, that wouldn't be Judge Thorpe. The judge that's assigned to those cases. I'm gonna appoint the public defender to represent Ms. Rainey on the new charge of domestic, of battery dating violence. Thank you, Ms. Rainey.
Subscribe to my YouTube channel so you can check out my show, Legal Insanity.
Okay, so this is Mohammed El Ayadi?
Yes, sir.
All right. So Mr. Reese is here on behalf of Mr. El Ayadi. These charges are possession of heroin, possession of cocaine, introducing contraband to the county facility, possession of less than 20 grams of cannabis, and possession of drug paraphernalia. Mr. Reese, you represent him on the old charge or the new charge or both?
Both charges, Your Honor. We just haven't filed our notice of appearance yet. That'll be filed tomorrow, fully retained this morning.
All right. And what would you like the court to do?
I have not had an opportunity to review the charging affidavit. It wasn't online this morning. I would defer to the court's determination of probable cause and not revoke the bond in the possession of paraphernalia case, which he is currently out on bond, and that is case number 2018 MM 6388. But for these two offenses, my client has not been ever previously arrested. He lives with his family here in Central Florida, and I told his family as well as him that if they want me to represent him, that he needs to make arrangements to contact somebody for substance abuse evaluation. The family's contacting Aspire, And that's going to take place no later than Monday, where I'm out of the case.
All right. Say, do you want to be heard on the revocation of the bond? It's a misdemeanor possession of drug paraphernalia, first degree misdemeanor, and the bond on that is $100.
Your Honor, State would be requesting a revocation of the bond just because the charges in that case were similar, although the paraphernalia was the charge filed. It was also of a drug nature, although that heroin charge wasn't ultimately charged. The State will just request that bond for that case be revoked.
Okay, all right. Do I have the authority, State, to increase the bond on the case in which he's out?
I don't know what that
I can-
bond
I'm
was,
getting a
Your
nod from
Honor.
the clerk, which means she's seen that happen before, so I'm gonna guess I do.
Yes.
Not that I'm suggesting that, do you have any opposition, or is there any legal authority that says I can't increase the bond?
No, Your Honor.
Okay, all right. All right, this is what I'm gonna do. I'm gonna find probable cause on the new charges. As to possession of heroin, I'm gonna set bond in the amount of $1,000. Possession of cocaine, I'm gonna set bond in the amount of $1,000. Introduction of contraband into the county facility, I'm gonna set bond in the amount of $1,000. Possession of cannabis, 500. Possession of drug paraphernalia, 500. So Sharon, that's the bonds currently, I'm leaving the bonds unchanged. As it relates to the case for which Mr. Eladi is out on bond, 2018 MM 6388A-0, based upon his collecting new law violations, I'm going, is it better that I revoke the bond and place a new bond?
Yeah, you just say, yeah, you revoke,
Okay.
you set a new bond.
All right, I'm gonna revoke the original bond through Van Waldner. That bond was at $100. I'm gonna set a new bond in the amount of $1,000. Mr. Eliade has retained private counsel who has counseled him to get into drug treatment, which I think is gonna be beneficial for Mr. Eliade. There's no need to consider appointment of a lawyer since Mr. Reese indicates he's gonna represent Mr. Eliade. I found probable cause and set bond. All right, thank you, Mr. Reese.
Just for clarification, there won't be a problem with the CF that was originally the case number that was transferred to misdemeanor, Madam Clerk? There won't be a problem with that, right?
No, because it's already set for the arraignment on August the 1st.
Okay.
Okay. So he's originally set for felonies, they filed a misdemeanor only?
Correct.
That's what the state was referring to? Okay, all right.
Yes, sir. Thanks so
All right,
much.
thank
Have a
you, good to
day.
see you. All right, is this Mr. Barasoni?
Yes, sir.
All right. All right, Mr. Barasoni is charged by arrest affidavit with trafficking in heroin, possession of cocaine with intent to sell or deliver, possession of alprazolam with intent for sale, possession of less than 20 grams, possession of drug paraphernalia, carrying concealed firearm, possession of concealed weapon by a convicted felon, driving a license suspended or revoked, reckless driving, fleeing and attempting to elude a police officer with disregard of safety causing injury or death.
And he got one more count, Judge.
Did I miss one?
Yeah, go to the third page at the end. Come up from the front. Judge, go back to the top, row 1, 2, 3. Yes. Right there.
Okay. Oh, an aggravated assault with a firearm. I have reviewed the charging affidavit. I find probable cause on all those charges. Okay, what does this mean that it says count 1, no bond, count 10, no
Yeah,
bond?
they did a bond correction. The judge, this is the officer,
Okay.
originally did it as $100,000.
Right.
But it should be a no bond.
Okay,
And then count 10, they put it as 150, which
Okay.
is a feeling to come in as a no bond.
okay, all right. All right. All right, State, do you want to be heard on bond amounts or any other conditions of release?
Your Honor, as far as the bond amount, we'll leave that in the discretion of Your Honor.
Okay,
State would just be requesting no contact with the victim of the assault.
okay. All right, Mr. Parker, anything you want me to know?
Can you set bond on the F3s at 500 apiece, on the trafficking at 2,500, and the possession of cocaine at 1,000, the alprazolam at 1,000, and then the misdemeanors at 100 each?
All right, and the trafficking, 100,000, you said?
2,500.
I'm either losing my hearing or the sound in here is terrible, and I can't figure out which it is. So your recommendation on the trafficking, which appears to be the largest, and the fleeing attempted to elude, which the officers requested no bond on those two. Talk to me about those.
On the fleeing to elude?
Yeah, I've got, count 1 is trafficking in heroin,
Right.
greater than 4 and less than 14 with a weapon. And the officer's requesting no bond on that. What is your argument as far as setting a bond?
There's no legal reason why he cannot get a bond on the trafficking charge
Okay.
today. I'd be interested to know what his rap sheet is, if any, with regard to prior traffickings and drugs or anything of that nature.
Okay. State, does he have any, what is his prior criminal history?
He has 22 prior felony convictions, Your Honor. A few of them are possession with intent to sell. There's some felony not trafficking, but traffic
Gotcha.
charges. So there's no other trafficking in drugs, but there's possession with intent to
Okay,
sell.
all right. All right, I'm gonna find probable cause. I'm gonna set bonds as follows. On the trafficking in heroin, I'm gonna set bond in the amount of $100,000. Possession of cocaine, $150. Possession of alprazolam, $150. Less than 20 grams of cannabis, $100. Possession of drug paraphernalia, $100. Carrying concealed firearm, $1,000. Possession of a concealed firearm by a convicted felon, $1,000. Driving with license suspended or revoked, $150. Reckless driving, $150. Fleeing or attempting to elude a police officer causing injury or death, I'm gonna set that at $5,000. And aggravated assault with a firearm, I'm gonna set that bond in the amount of $5,000. The alleged victim in this case, I know that we've got law enforcement involved. Ms. Hayes, is there this isn't a domestic ag assault, is it?
No, it's not. based on the
I'm seeing an interaction downtown on Washington and Magnolia with law enforcement.
Yes, Your Honor. It looks like the victim's name is first name of Fouad, last name Naime.
Okay, all right. Where is Fouad's name? Oh, there he is. Okay. Fouad Naime, who's operating the gray Toyota. I'm gonna require that the defendant have no contact directly or indirectly with Mr. Fouad. He's also not to possess any firearms or weapons, which he's already not permitted to do because of his convicted felon status. He's also not to consume any alcohol or drugs while on release. I'm appointing the Public Defender's Office to represent him. Good luck, Mr. Bersoni. Did you get all those that time? All right. Behazine Bridges. Mr. Bridges is charged with possession of meth.
Judge, he qualifies for straight PTR, the drug charge. I think that there might be a TR hold.
I see there's a warrant for child support.
He just is interested to know if there's a purge amount.
Purge amount is $8,256.29. So I can't do anything with the purge. He qualifies for pretrial release?
He does qualify.
All right, I'll go ahead and release him in pretrial release. Appoint the public defender's office to represent him. Find a factual basis on the charge of possession of ecstasy. And I can't do anything on the child support purge.
Thank you.
Thank you.
I think he go down to.
Sorry,
Tomorrow.
Okay.
Was the bond set on the drug charge?
Pretrial release.
Okay.
Pretrial release. Based upon your recommendation, his qualification for that, there's just nothing I can do on the child support purge amount.
Would I be
All right.
going? One question. Would I be going?
I've appointed the public defender's office to represent you. You're gonna wanna whisper in Mr. Parker's ear,
About
see?
the child
It's
support
about the
issue.
child.
Nothing I can do, sir.
No, I was saying, do I have court tomorrow for it?
I've been told you have court tomorrow. All right? Thanks, sir. Louisman Casa Major.
So,
All right, Mr. Casa Major, you're charged with burglary to a conveyance, aggravated battery with a motor vehicle, and criminal mischief. Victim in this is Nadage Jacques. State, what is Mr. Casa Major's priors?
Your Honor, it looks like he has 5 prior felony convictions and 4 prior misdemeanors. There was a similar charge open, but that's since been dropped from our office.
All right, I'm gonna find probable cause on the 3 charges. I'm gonna set bond on the burglary with a battery or assault. I'm gonna set bond in the amount of $5,000. On the aggravated battery of the motor vehicle, I'm gonna set bond in the amount of $2,500. On the criminal mischief, I'm gonna set bond in the amount of $150. So it should be $76.50. All right. I'm gonna require that Mr. Casa Major have no contact directly or indirectly with Nadege Jacques. They don't appear to reside together or know each other in any sort of familial way, so there's no other requirement that I do that. Mr. Casa Major is to possess no firearms or weapons, consume no alcohol or recreational drugs. I'm gonna appoint the public defender's office to represent him on these charges. Good
Your
luck,
Honor,
sir.
can I say one word? I
No,
never
sir.
carry a weapon.
No,
I
sir.
would not. I wouldn't say anything.
Adrian Cintron,
Medical, Your Honor.
I'm sorry?
Medical?
Okay,
Can we reset for tomorrow, please?
all right, reset that for tomorrow. Works for me, I won't be here. Corey Cox.
Yes, sir.
All right. Cox is charged with possession of cocaine. She's also charged with aggravated assault with a deadly weapon. All right, I'm gonna find probable cause on the charge of aggravated assault with a deadly weapon. I'm gonna set bond in the amount of $2,500. I'm gonna appoint the public defender's office to represent her in this charge. I'm also gonna require that she have no contact directly or indirectly with Angela Ashcraft. She's not to consume any alcohol or drugs. She's not to possess any weapons or firearms. On the charge of possession of cocaine, I'm gonna find a factual basis, set bond in the amount of $1,000. Appoint the public defender's office on both cases. Good luck, Ms. Cox. Michael Hill. All right, so I have Mr. Hill's charged with possession of drug paraphernalia. Now, is the petty theft, is he out on bond on other petty thefts and then picked up another petty theft, or is?
I believe so, Judge.
Yeah.
We're gonna ask the court to set a bond of $1,000 on the petty theft and $500 on the drug paraphernalia charge, and to consider not revoking his bond in the previous case, as his new charge is the same but not a violent offense.
Okay. All right, I'm going to find PC on both the charges. I'm gonna set bond in the amount of $1,000 on the petty theft, $500 on the drug paraphernalia. I'm gonna appoint the public defender to represent Mr. Hill on both cases. I am gonna revoke his bond on the 2018 CF 8970A-0. He can seek a reimposition of conditions of release from that judge. And I've appointed the public defender.
Thank you, Judge.
Hi, good morning. Mark Jackson. Mr. Jackson's charged with aggravated assault with a weapon. All right, it appears as though the weapon is a liquor bottle. The charging affidavit's a little unclear. Did he, was he already arrested and then bonded out and then went back to the location where this occurred?
No.
State, is that what you're understanding?
Your Honor, let me check really quick if we have two
Yeah,
separate cases.
because what the affidavit says is that
Yeah.
Jackson was arrested on aggravated assault charges from July 15th.
Right.
You know what, this charging affidavit is from July 15th?
Yeah.
Yeah, Your Honor, I only have the one
Okay.
charge.
Maybe was there a warrant issue? Well, I don't know what happened in the last week, but I've answered the question, I have the answer to the question that concerned me. So what I'm gonna do is, based upon the charging affidavit, or the arrest affidavit, I'm sorry, I'm gonna find that there's probable cause for aggravated assault with a weapon. I'm gonna set bond in the amount of $1,000. I'm gonna appoint the public defender's office to represent Mr. Jackson. In order that Mr. Jackson not have any contact with Ian Cannaby. That's Kanaby. He's also not to return to the Blue Jeans Bar at 901 East Cimarron Boulevard in Apopka. And I'm appointing the Public Defender's Office to represent Mr. Jackson. Gary Logsden. Okay. That would be reset for tomorrow. Nicholas McCormick. Mr. McCormick has a warrant for failure to appear. On the charge of driving while license suspended or revoked. Failed to appear for his arraignment on May 24th. I'm gonna come back to that one. I've got the grand theft, third degree, dealing in stolen property and receiving money from a pawnbroker. There's a warrant out for that. That warrant comes from Judge Allen. She has set bond in the amount of $5,000 on the grand theft, $150 on the dealing in stolen property, and $100 on the receiving money from a pawnbroker. I'm gonna leave those bonds in place. I'm gonna set bond on the driving while license suspended or revoked in the amount of $500. I'm gonna appoint the Public Defender's Office to represent Mr. McCormick on the theft charges in 2018 CF 3759, as well as on the failure to appear for the driving charge on 2018 CF 3214. File probable cause on both if I didn't say that. Natalie Rodriguez Cajigas?
Yes.
Miss Rodriguez Cajigas is apparently out on bond on a charge of petty theft. And she picked up charges of possession of meth, possession of less than 20 grams of cannabis, and possession of drug paraphernalia.
Judge, we're not gonna make a PC argument, but we would ask the court set bond at $1,000 on the MDMA charge, and then $100 on each of the 2 remaining misdemeanors.
The charging affidavit also talks about introduction of contraband. I don't see that as a charge.
I don't either.
Okay, so I'm just working with the 3. All right, I'm gonna find probable cause on the 3 charges contained in the arrest affidavit. I'm gonna set bond on the MDMA at $1,000, less than 20 grams of cannabis at 100, possession of drug paraphernalia at 100. This petty theft charge goes back to 2017. And it says return date to be TBA, I guess. Is she in pretrial diversion for that?
I did.
I don't want you to say, I'm sorry, I asked a question, but I don't want you to answer that, Ms. Rodriguez. Could you? Do you know, Madam Clerk, what's the story with the,
Your Honor, it looks like that case just kind of fell off the docket. It was set for arraignment in April, and then I
Okay.
believe with.
all right, that happens. All right, what I'm gonna do is, I'm not gonna take any action on revoking the bond on the petty theft. I've found PC. I'm gonna appoint the Public Defender's Office to represent Ms. Rodriguez Kajigas. Thank you, Ms. Hayes. Irene Santana. Okay, I have the thing I need to learn today. I try to learn one thing every day. Apparently, there's a charge of possession of grocery cart or dairy case.
Yeah, and also, I don't know how they determine the value of a used shopping cart. I suspect that it's probably not over $300, even though it states it's $550.
Does chapter 506.509 indicate that grocery carts are just automatically considered to be grand theft,
Well,
as in
there's
a
two,
vehicle?
There's two counts, so
Oh,
count
I
two-
see.
Yeah, count two's the misdemeanor.
You're absolutely right, Mr. Parker.
So I know that on the face of the PCF, David, it says it's worth $550.
Gotcha. It does.
I'd be interested to know how they estimate the
Me
value.
too. All right. I'm gonna find probable cause on these two charges. On the grand theft, I'm gonna set bond in the amount of $500. On the possession of a grocery cart, I'm gonna set bond at $100 for a total of $600. I'm gonna appoint the Public Defender's Office to represent Ms. Santana on both of these charges.
Thank you, Judge.
And I learned a new thing. Chapter 506 exists. Mr. Parker, have you ever seen that statute before? Possession of a shopping cart or possession of shopping cart or dairy case or something?
I haven't worked in misdemeanors probably since like 2013, so I haven't seen it.
Ms. Hayes, you ever heard of that?
I have not, but I have now.
There you go, we all learned something today. All right, I have Edgar Santiago, that makes me feel a little bit better. All right, we have Edgar Santiago charged with aggravated assault, kidnapping, aggravated battery, carjacking, possession of a firearm by a convicted felon, attempted second-degree murder with a weapon. Apparently there was a warrant for Mr. Santiago. It was signed by me. All right, Mr. Parker, do you want to, oh, and then he was also out on bond for possession of ammunition by a convicted felon, possession of a firearm by a convicted felon, reckless display of a firearm, and discharging a firearm in public. That's on 2018 CF 1768A-0, which he bonded out on in February. Mr. Parker, do you want to be heard on the issue of bond?
Yes, after speaking with Mr. Santiago, on the attempted second-degree murder, we'd ask the court set bond in the amount of $10,000.
I'm sorry, Mr. Parker.
$10,000 on the attempted second. On the possession of a firearm by convicted felon, $1,000. The carjacking at $2,500, and $1,000 on the aggravated battery, and $1,000 on the kidnapping, and $1,000 on the aggravated assault.
All right, Ms. Hayes, other than the charges for which Mr. Santiago was out on bond when he collected these new charges, does he have other priors?
Yes, Your Honor, it looks like he just finished a sentence in the Department of Corrections for, it was 2 different cases for robbery with a firearm, aggravated assault with a firearm, possession by, of a firearm by a convicted delinquent. I'm trying to get the release date if Your Honor's interested. But
All right, I'm gonna find probable cause on all these charges. I'm going to, set bond on the attempted second-degree murder with a weapon at $100,000. Possession of a firearm by a convicted felon at $5,000. Carjacking at $5,000. Aggravated battery at $5,000. Kidnapping at $5,000. Aggravated assault at, $5,000. You know what, I'll set that at $1,000. I'm also going to revoke his conditions of release on 2018 CF 1768A-0. Appoint the public defender to represent Mr. Santiago. Did you get all those numbers? Okay.
I'm sorry, Your Honor, on the attempted second-degree murder and possession of a firearm, I missed the bond amount.
Second degree, 100,000, and possession of firearm, 5,000.
Thank you.
Michelle Soto. All right, Michelle Soto is charged with possession of meth, introduction of contraband into a county facility, possession of less than 20 grams of cannabis, and possession of drug paraphernalia. She's also charged with, that's in 2018 CF 10354. She's charged with other counts in 2018 CF 10357 with introduction of contraband into a county facility, possession of cannabis, and possession of drug paraphernalia.
We just asked that the court set bond. We have no PC argument, but that she does qualify for straight pretrial release, so we'd ask that the court consider doing that.
So was she arrested on the?
It's all same day. Yeah.
All right, and then because I don't know how she could it seems like a duplication of charges. Mr. Parker, did you have a chance to read the?
Yeah, unless they're alleging that they found cannabis on her at the time of the initial arrest and then allegedly found more cannabis upon coming into the jail, it would be a duplicate.
All right. I don't understand that you're contesting probable cause. So I'm gonna. Does Miss Soto have criminal history?
No, Your Honor.
All right. What I'm gonna do is I'm gonna find probable cause. I'm gonna release her on pretrial release on all charges. I'm gonna appoint the Office of the Public Defender to represent her on these charges. Good luck, Ms. Soto.
Thank you.
Hey folks, don't forget to subscribe to my YouTube channel so you can check out my show, Legal Insanity.
A little overcharged.
Anthony Tripke.
Anthony Thripke.
Yes.
Mr. Thripke is charged with battery on a law enforcement officer and resisting an officer without violence. Ah, the Knights Library. Mr. Is it Thripke or, oh, it's Tripke?
Yes.
Where did I get Thripke? All right. Does Mr. Tripke have any prior criminal history?
No.
No, Your Honor.
All right, I'm gonna find probable cause on the battery and resisting an officer without violence. I'm gonna release him on pretrial release. Appoint the Office of the Public Defender to represent him. Good luck, Mr. Tripke.
Joseph Villanueva.
All right, Mr. Villanueva is charged with failure to appear on the charge of burglary to a conveyance. He failed to appear for a plea hearing on June 21st. Bond was set on none. I'm going to stay the bond at none. Appoint the Office of the Public Defender to represent him.
Judge, given that it's a non-violent F3, would the court consider setting a bond of $1,000 or $2,000 rather than having him stay no bond until his court date?
Well, the capias that was issued by felony judge says revoke release, revoke PTR. So he was originally out on PTR?
Yes, sir.
All right, it doesn't say that I shouldn't set bond.
His attorney is Zachary Phillips.
Zachary Phil?
Your Honor, state's only argument on this case is that he's failed to appear twice for this case alone.
Really? Okay. All right, what I'm gonna do, I don't know the underlying charges, however, Mr. Villanueva has not appeared in court. What I'm gonna do is I'm gonna set bond in the amount of $5,000. And I'm going to, as I said, well, there's a warrant, so that's the factual basis, and I'm appointing the Public Defender's Office to represent him.
No, Judge, you have a Zachary, P-H-I-P-P-S.
Phipps?
Yeah, that's his attorney.
Okay.
Yeah, we can't appoint him.
Oh, I'm sorry, that's why you told me that. Never mind, I'm not appointing Mr. Mr. Villanueva, Mr. Villanueva, do you still have Mr. Phipps as your lawyer?
I haven't talked to him recently because I recently just got out of rehab.
Okay, don't want you to say anything else. You haven't talked to him recently, he still has filed a notice of appearance?
Yes,
All right, so I'm not appointing the Office of the Public Defender. When you get to court, should you decide you want to discharge him and hire a different lawyer or have the Public Defender appointed, you can do that. But I'm not appointing the Public Defender because he already has a lawyer. Thank you, Madam Clerk. Thank you, Mr. Villanueva.
You said 5,000?
5,000. Mary Perez Merced. Ms. Perez Merced is charged with failure to appear on a charge of petty theft. She has a warrant out of Osceola County for violation of probation for petty theft. The bond amount on the original capias sets bond in the amount of $2,500.
You said Osceola? Is it Osceola or Orange?
This is Orange. Apparently, she failed to appear in Orange, and she has an out-of-county VOP on a felony out of Osceola, 15 CF 1554. I don't have any information on that, so I don't think that's anything I need to concern myself with. I'm going to set bond on the failure to appear on the retail theft in the amount set by the original judge for her failure to appear back in May of 2016. So I'm going to set that bond in the amount of $2,500 and appoint the Public Defender's Office. Madam Interpreter, we will get to you as quickly as we can, okay? You good? All right, sure. All right, I have Alva Renga Lucas. Charged with leaving the scene of an accident.
What's the inmate number? Last name is Gustaf, G-U-A-S-T. No, what's the inmate number?
The inmate number is 180-22038. It looks like Alva Rangagustelli. This doesn't look like.
Judge, sorry, this is Mr. Pope. I'm just talking.
I was gonna.
Oh, that's him?
What's the inmate number?
What's the inmate number again? The inmate number.
Oh, I'm sorry. You're talking to me. 180-22038. He bonded. I'm not gonna spend any more effort on that. Thank you. You gotta let me know these things. All right. Is this Mr. Lopez Gabriel?
No, sir.
He bonded. Keep it rolling, keep it rolling. Mr. Pope.
Yes, sir.
All right. Mr. Pope is charged with failing to appear for arraignment on the charge of DUI.
Judge, I believe his address is not correct with the clerk. I've indicated to him that it's his responsibility to make sure his address is correct so that he gets his court paperwork. Would the court consider RORing him on this driving offense or setting bonding amount of $1,000?
Well, I'm gonna guess since this is a DUI, did he have a bondsman?
Yes.
Okay. So his bondsman really should have kept him advised as to what was going on. And this also goes back to March.
Yeah, but I had never received.
Okay, I don't want you to say anything, Mr. Pope. I know it seems as though I'm inviting you to converse with me, but
Oh, I'm sorry.
the problem is, we're being recorded in the states here. Your lawyer may not want you to say some things, okay? Do we know what judge this is in front of?
Yes, Your Honor, this is Judge Starr.
Judge Starr? Okay. All right. What I'll do is I'll set bond in the amount of $1,500 for the failure to appear. And I don't know, was Mr. Pope previously appointed the public defender, or I need to appoint the public defender?
And, officer said he had an emergency warrant in the queue that he needs you to get ready.
An emergency warrant, okay.
No, he did not have a count.
All right, I'll appoint the public defender's office to represent him on the DUI and set bond, as I said, I think $1,500. Is there something else I need to look at?
Nope,
Nope,
that's it.
okay. All right, I have Scott Wenzel. Mr. Wenzel's charged with DUI.
Judge, he does qualify for straight PTR on this DUI.
Okay. All right. I'm going to release him on pretrial release. Appoint the public defender's office to represent Mr. Wenzel. Oh, wait. I have a note that says does not qualify. Let's see. He does qualify?
For the public defender.
Yes. 1,500 every 2 weeks? Yeah, he would qualify. Every 2 weeks?
No, he does not qualify.
What's the number?
927.
Oh, okay. All right, then I'm not appointing the public defender. Mr. Wenzel will go into the marketplace and hire private counsel.
You heard me what I said. Officer said he had emergency warrants.
Oh, the emergency, that's what that meant. Okay, well, I'll get to him as soon as I'm done here. I brought the computer, I brought my Surface with me, so I can do that when I take a break.
Okay.
Can someone get a message to him, or is the officer here?
No, he had, called, I guess, in the back.
Okay.
I let the ladies know if you call again that you told me.
Yeah, I may be able to take a break, in the next 45 minutes.
Okay.
So if they call again, that's what I'll do, but
Okay.
I can only do one thing. I'm a one-trick pony, I can only do one thing at a time. That's why I leave the phone over there, because I used to bring it with me on the bench and I was divided. Okay. So now we have Jamie Davis. Mr. Davis is charged with trespass in an unoccupied structure, resisting without violence, and false information to a law enforcement officer. All right, I'm gonna find probable cause. State, if Mr. Davis wanted to resolve these charges today, do you have a recommendation?
Yes, Your Honor, he doesn't have any criminal history, so state's offer would just be an adjudication credit time served.
Wow. How many days does he have in? 1 or 2? 2 days? All right, Mr. Davis, did you want to resolve this today by entering a plea of guilty to the 3 charges?
Judge, can I have a second?
You may. Yes. I think what I'll do I've got the interpreter though,
Yeah.
I've gotta get, can we interrupt these and do the interpreter cases so we can get her on the wall?
But she got to interpret. by
Oh, she's
herself.
got Osceola County, okay. All right, so let me do this. Should we stop these, do Osceola?
I mean, it's up to you.
It's all the same, right?
Yeah,
All right, let's do this. Let's get through, this isn't that many.
okay.
Let's get through these.
Then we do the interpreter
Um,
and also,
Right, I wonder, I don't know how urgent a warrant would be on a Saturday, Sunday afternoon.
I mean, after we finish Orange and do the interpreter.
Judge,
So we take a break.
Do warrants,
Right.
yeah, and then we get the Osceola.
Yeah, let's do that, because they're not going anywhere.
They ain't going nowhere.
Okay, all right, we got a plan.
I don't feel comfortable leading him
Okay.
to a crime of dishonesty at first appearance
I understand.
with someone with no history, but I think he feels it's in his best interest.
All right, let me approach it this way. Based upon Mr. Davis having no prior criminal history, what I'll do is, based upon the facts contained in the arrest affidavit, I am going to find probable cause. I am going to release him on his own recognizance. I have Mr. Davis as being a transient, so I need to spend a moment with him explaining to him what that means. But ultimately, I can, he'll have to come back to court for these things, but he's gonna get out today. Alternatively, if he wants to, so either way, he's gonna get out today. If he doesn't wanna have to come back to court, certainly he's encouraged to follow advice of counsel, but if he doesn't wanna have to come back and wants to enter pleas, I'll accept pleas, adjudicate him guilty of the 3 offenses, and sentence him to time served. So those are his 2 choices. Either way, he's getting out today. I don't want Mr. Davis to feel that he's gotta enter pleas to these charges to get out, because I'm gonna release him anyway. It's a question of whether he wants to come back or not. So with that new information, do you wanna just, Mr. Davis, do you wanna just chat with your lawyer just for a moment? See if that changes how you wanna, or directs
Sure.
what you wanna do? He has a what? He has a writ for what? Oh, is it child support? Is it child support? Contempt of court? All right. All right, Mr. Davis? Yes. I've just been corrected. Apparently, you'll be out today. I'll still release you ROR on these.
Yes, sir.
But you apparently have something else holding you. You have some sort of contempt writ from domestic relations that I have no control over. So that may make a difference as to what you want to do. Okay?
Yeah, I just want to get out of here and go back to work tomorrow.
Okay. Even though I can really, Mr. Parker will explain to you what's going on. Seems like every time I start getting some forward momentum, it pulls you down.
There's no writ. When was that? When was that?
I have just been informed that there's a writ holding you until you, when does he go to court on that DR contempt? Do you know? He hasn't been served yet?
Yeah.
So, in the next couple days? All right, so he's not going anywhere? Okay. All right, let me do this. I'm gonna find, see if I let him out ROR, he's not gonna get out, he won't get credit. All right, let me do this. I'm gonna find probable cause. I'm gonna set bond in the amount of $100 on each charge. I'm gonna appoint the Public Defender's Office to represent Mr. Davis. Mr. Davis will have an opportunity to consult with his lawyer. If he's gonna be in custody, can he request can we reset him for tomorrow, or how does he, if he wants to get this resolved?
The
Public
attorney-
Defender's Office will,
Yeah, they'll file a motion with the judge and they'll put them on the docket. We don't-
okay, all right. Mr. Parker, does that sound like a plan?
Yes, Judge.
So rather than RORing him, he'll get credit for the time that he's in, so I'm gonna set a minimum bond. I'm appointing the Public Defender's Office. Mr. Davis will have a chance to talk to his lawyer, and if you wanna get back on the docket to address these cases, you can do that, later in the week. All right,
Thank you.
thank you. All right. John Eugene,
Mental health, Your Honor.
okay. Reset for tomorrow? Rodney Falk. Mr. Falk's charged with disorderly intoxication. State, does Mr. Falk have any prior criminal history?
Yes, Your Honor. He does have a prior disorderly conduct. He also has 43 felony convictions and 46 misdemeanor convictions.
Okay. All right, I'm gonna find probable cause. I'm gonna set bond in the amount of $250. I'm gonna appoint the public defender's office to represent Mr. Falk.
Thank you, Judge.
Jeremy Lloyd. Mr. Lloyd's charged with trespass. All right, I'm gonna find probable cause on the simple trespass. I'm gonna set bond in the amount of $250. Appoint the public defender's office to represent Mr. Lloyd. The possession of a firearm or ammunition subject to a domestic violence injunction. I'm gonna set bond in the amount of $1,000 on the first two counts. As to possession of an unlawful firearm, on count 3, I'm gonna set bond in the amount of $2,500. On the count of possession of cocaine, I'm going to set bond in the amount of $1,000. Charge of possession of less than 20 grams of cannabis, I'm gonna set bond in the amount of $500. Drug paraphernalia, I'm gonna set bond in the amount of $500. And on the violation of injunction against domestic violence, I'm gonna set bond in the amount of $1,500. Did you get all those numbers? What is that total? Sorry, making you do math.
6,500.
All right.
No, 6, 7.
$8,000, all right. And I'm go ahead and appoint the Office of the Public Defender to represent Mr. Jeffries. Shanika Johnson. Okay. Can you do me a favor and just write somewhere on this piece of paper something that identifies that it's Mr. Jeffries?
Okay,
Because it's on its own page, I don't want them to get separated.
okay.
Thank you. All right, Ms. Johnson is charged with battery on Javon Johnson.
No FTAs or VOPs, Judge. She does qualify for direct PTR.
All right. All right, I'm going to find probable cause on the charge of battery. I don't know if this is it is DV. All right, I'm going to release Ms. Johnson on pretrial release. I'm going to order that she have. Does Ms. Johnson and Mr. Johnson reside in the same home together?
Yes, Your Honor, we do.
Okay. Have we heard from Mr. Johnson as to what he would like to have, what contact he would like to have with his wife?
No, Your Honor, we were unable to contact.
Okay.
Defense would request a no hostile contact, Your Honor.
Your Honor, state would be requesting no contact, and then if the victim wants contact, they can later modify that.
Well, the charging affidavit indicates that at the time of the, this alleged battery, Mr. Johnson had packed a bag to leave the house. So I'm going to interpret that to mean that Mr. Johnson wishes to not be with Mrs. Johnson at this time. So I'm going to order no contact directly or indirectly. And as the state has indicated, if Mr. Johnson wants to contact the state attorney's office in regards to a modification of that contact, he is free to do so. I'm going to order that they maintain separate residences. Ms. Johnson will be permitted to return to the marital home one time with law enforcement to collect any personal items. She's also not to consume alcohol or recreational drugs, weapons or firearms during her condition as a condition of her release. I'm also going to appoint the public defender's office to represent her. Yes. I mean, yes. Darlene Lightcap. We don't have Milton Lightcap here, do we?
No, Your Honor. Not here.
All right, I've reviewed the charging affidavit. I'm going to find probable cause on the charge of aggravated battery with a deadly weapon. I'm going to set bond in the amount of $1,000. The deadly weapon being a cane. Apparently the Lightcaps have been married for 38 years. We heard from Mr. Lightcap as far as his desire to be in contact with his wife.
No, Your Honor. No.
All right, based upon the facts contained in the charging affidavit, I'm going to order that the defendant have no contact directly or indirectly with Mr. Lightcap. He can always contact the state